Mommy, do you have something on in your background? I hear
Oh,
something like,
yeah. Sorry. Go ahead. Go ahead. I turned it off.
yeah. All right. Okay. All right. Here we go. Hello, 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 everybody. Jump on in. Give you guys a minute to jump on in. What's up? What's up? What's up? Hello, everyone. Once again, we are back with another one. Let's see. Let's see who's out there. We got 4 people out there. Say hello. What's going on?
Hello, everyone. Glad to be back. Looking forward to having another riveting legal discussion with you all today.
Yes, ma'am. Yes, ma'am. We are ready. We are ready. We are going to talk about the memorandum of law, which was in support of the government's motion in limine to admit certain evidence and preclude other evidence and arguments at trial. Now, this came out on July 23rd of 2021. Um, but I brought Miss Esquire on so she can go over it with us, certain points in the motion. So anybody who's out there in the background, don't be shy. Say hello. I don't care where you from. It would be nice if you cannot be rude and say hello. And while you're there, hit the like button, please. Matter of fact, let me put on my reminder. Please don't forget, subscribe if you are not subscribed to my channel. And please subscribe to Empowered Esquire TV as well. That is my guest YouTube channel. Please follow. Thank you. And don't forget to like the video and share, share, share. Okay, so we are going to open this up. Let me share my screen. Which one is it again? Wait. It is. This one is 0. Okay. Sorry about that, guys. Okay. Yep, we're at the right docket. Let me make this bigger for everyone. You can all see that. Let me double check. Okay. We are good. Hello, hello, hello to the 9 people in the bushes. 10 now. Say hello, guys. Don't be shy. What is going on, y'all? Why are we hiding from Diva?
I don't know, Diva. You scaring people around here? You're intimidating them?
Girl, I don't know what is going on. It's making me nervous. Shit. Hey, I am Queen. What's up? Just V. Reverend Fat Boy. What's up? What's up? What's up, guys? Hello. All right, so you'll be in the bushes? Okay, everybody sit in the bushes. Hey, Missy. What's up, Mama? Hello, beautiful ladies. They're saying hello to you, Miss Esquire, as well.
Hello,
Matter of fact,
everyone.
Miss Esquire, can you see the chat?
You know what? I'm going to pull something up on a separate device because I want to make sure that I can also see the chat. So let me make that happen.
Yeah, yeah,
One
yeah,
second.
definitely.
Okay, now I can see the chat, and I'm going to say hello to everyone as well.
Hey, what's
Hello,
up?
everyone. All right, perfect. All right, yes.
The divas are in the building. Mertice, what's up, baby? Hi. All right, so we're gonna go over, like I said, the memorandum that the government had put in. Now, we all know that our brother Atmos went over it, our sister Angie went over it, but it's my turn to go over it. And we all know what they were talking about with the preliminary statements. I'm not going to go over that. We all know what the background is. What we are going to go over is the legal standard, which I had questions about it. So in this portion, it says that the Federal Rule of Evidence 412 expressly provides that in a criminal proceeding involving sexual misconduct, evidence offered to prove that a victim engaged in other sexual behavior or evidence offered to prove a victim's sexual predisposition is not admissible except in 3 narrow circumstances. Now, Miss Esquire, what does all that mean?
So, in other words, if someone is being charged with sexually assaulting someone, the victim's past, as far as their past lovers, their past sexual behaviors, things like that, that is not permitted to be allowed into the case unless you meet the exception which they're about to refer to.
Okay. And that is the Federal R Evidence 412A Rule 412 aims to safeguard the alleged victim against the invasion of privacy, potential embarrassment, and sexual stereotyping that is associated with public disclosure of intimate sexual details, and to encourage victims of sexual misconduct to institute and to participate in legal proceedings against alleged offenders. All right, now what does that mean?
So, I think the last time I was on your channel, I mentioned to everyone that the federal government can be flexible with the statute of limitations when it comes to sex crimes. So, as part of their policy to encourage, just as they were saying, to encourage victims to come forward, the federal government has done a number of things that are really unique only to these types of cases. So, one of those things is that they gave themselves flexibility with the statute of limitations. They can be flexible on that. That is partially why they are permitted to bring the Aaliyah accusations into his current charges. But also, what they're
Right.
saying is whenever it comes to these types of cases, we want to encourage victims to come forward. And that is part of the reason that we are also creating this rule, which says, in general, you're not permitted to talk about their sexual history. If you think about it from a common sense perspective, what a lot of criminal defense attorneys used to do is they used to just insinuate that the victim is promiscuous or
Mm,
insinuate that the victim is a prostitute, and they would
right.
use that to try to hurt the credibility of the victims. So
Right.
that is part of the reason why the government has created this rule, which says no, we don't want to hear about that. We don't want to hear about whether or not they have a lot of sexual partners. We don't want to hear about what they do in their free time because their history is not relevant and it's only being used to intimidate them. So you would find that women who did have quote unquote active sexual histories, they wouldn't report being abused because they would say, well, you know, they're going to talk about my history and I'm embarrassed. So this
Right.
entire rule was created to protect the victim from feeling that they can't come forward because their history is going to be on the table for discussion.
Mm, interesting. I wonder, I wonder if the judge is gonna let this rock. What do you think?
You know, I think that for the most part, especially because a lot of these women were allegedly minors when the
Right.
conduct began, I think for the
Right.
most part, the judge is going to say, you know, I don't want to hear about their outside romantic or intimate relationships for the most part, unless it is directly linked to these accusations. So, for example, the
Mm,
accusations that R. Kelly would make or would coerce the girls and women into doing other things with other people, well,
right.
then that makes those other actions with other people relevant. But other than that, I don't think the judge will allow this kind of broad conversation about their intimate histories.
Right. So it doesn't matter if the girls had sex with him and they weren't virgins. In other words, that's not going to be
Right. That
relevant
is
to the case.
totally irrelevant. Yeah, that's totally irrelevant.
Okay. Okay. So let's get that out the way. You know who you people in the bushes, sitting back can understand that. Okay. Okay. And applying rule 412, shall I say, to preclude evidence of sex trafficking victims, prostitution, both prior to and following the defendant's conduct, and Rule 412 imposes clear limits on a defendant's ability to introduce evidence that a victim engaged in other sexual behavior or has propensity to engage in sexual acts in the context of criminal cases. So the rule prescribes very limited exceptions to this inadmissibility. So that's basically what you were just explaining to us, right?
Yes, that's exactly what I was just explaining. That for the most part, it doesn't matter if they want to allege, and quite frankly, I think if R. Kelly's defense counsel takes it there, if they try to allege that these girls were already active or already selling their
Right,
bodies or whatever, first of all,
right.
the judge will probably not allow that in. And if
Mm,
somehow it gets in, well, let me clarify that because I talked about this on my channel, but I don't think I've ever said it here.
okay,
So just like every other profession has their slang, right? In the
right.
legal world, we have our slang. So when we're
Yes.
talking about something that is admissible or inadmissible in court, we don't say, well, that would be admissible or that would be inadmissible when we're speaking to each
Mm.
other. We say, is it going to get in or no? Like that's our slang. So
Okay.
right. So when I say, oh, I don't think that would get in, I don't think any past history they had as far as I guess I have to say sex work. I think that's the best way to describe it. I don't think
Right,
that would get in. Or them being
right,
virgins or not being virgins, I don't
right.
think that would get in. And
Okay.
if in fact it does, they are actually not doing themselves a favor. Because if I am the prosecutor and somehow you're able to get into my victim having a history for prostitution or, being someone who wasn't a virgin, and at the time my victim was allegedly a minor, you're actually not going to hurt me. I'm going to use that because now I'm going to say to the jury, you've heard that my victim was already victimized. And all R.
Right,
Kelly came is did along and further victimized her, which makes him
right.
even more culpable that he took a victim and instead of reporting it to the police, he further victimized them. So if they're
Mm,
trying to go for these women were already victims and they think that's going to help them, that's not a good idea because you're just further establishing that this person has no scruples. They found someone who is being victimized and just jumped on the victimization train.
right, right. Like some of these girls have history of prior sexual abuse within their family members or people outside. Um, you know, they might want to use that. There's a lot of
And if
YouTube
they
evidence.
right, and if they try to use that again, anyone who thinks you posted a short the other day that I saw and I was like, oh, she's so right. And you said anyone who thinks they're helping R. Kelly, you're hurting them. And you are
Yes.
so correct. If they
Yes.
think they are helping R. Kelly by trying to establish that these women were already, victimized and
Right.
already taken advantage of by other
Right.
adults, you're only establishing that this person is a victim.
Yeah, he's a
And
monster.
you're not in any way hurting the case against R. Kelly now. You're just establishing that this person is already a victim. And also, you're establishing a lovely explanation for any outburst this person may have online. Well, even, because all the prosecution has to say is my victim, my witness, has been being victimized even before R. Kelly, and that explains her outburst online. Members of the jury, you must forgive her. She has been a victim her entire life.
Right. 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 Wow. I tell you, that just further proves that he's a monster. You know, that's like them saying that he was set up. You know what I mean? Like, all right, so if he was set up, that means he did some shit. he was complicit.
Right. Right. That is exactly correct. Because if they are saying allegedly, if they're trying to use that to allegedly say that he was set up, it's exactly what you said, Diva. How can someone set you up to sleep with a minor? Were you out
Right.
there soliciting? Were you out there soliciting minors and then you found one? I mean, it doesn't. It's not helping.
Apparently, the enterprise was out there soliciting. So you're just admitting that he was doing these things.
Precisely. You are just proving that he did have a system by which he was soliciting minors who are already in that, who are already forced into that line of work.
Exactly. Exactly. And then in another part, it says that uh, a crime victim has the right to be treated with fairness and with respect for the victim's dignity and privacy. And um, and then it talks about that, it says that, as noted above, when a defendant intends to assert that a victim's sexual behavior other than with him, or in this case, others at his direction, Rule 412 requires that the defendant file notice 14 days in advance of trial. The defendant has not provided the required notice, and the government respectfully submits that there would be no basis to do so here. Here, any evidence of a victim's sexual behavior with anyone other than the defendant or the other persons at the defendant's direction, as well as evidence of any purported sexual predisposition, would be wholly irrelevant to the charges against the defendant. The exclusion of evidence on these topics is thus appropriate under Rule 412. Now, what is that?
So, in other words, the government is saying, Your Honor, R. Kelly's defense has not disclosed that they plan on using any of our victims' past conduct. And if, in fact, they did plan on doing so, more than likely, it would be someone that one of our victims allegedly interacted with because R. Kelly directed it. So it would not be something that falls within the realm of 412. So, in other words, they're saying if he plans on using something outside of something he allegedly directed, he can't
Mm,
because he hasn't disclosed it and we don't see how it would be relevant.
mm. So, okay, so say for instance, they talk about how Azriel, Jane Doe 5, knows she wound up downloading porn, um, gay porn for R. Kelly. Now, in other words, they can't use that against her, right?
No, she did that at his direction.
Right.
Now they can
Right.
discuss it. They can discuss it if they want to discuss it for some reason. It's relevant, but they can't try to use it against her. She did it at his direction.
So, and how do you prove something like that?
I mean, well, they could use the records of the search history on the computer. They could use the actual video and trace it to an IP address, and then
Well,
they could
they did
have.
do that. They
Okay.
did actually find the, she gave them the names of the sites and stuff. So they
Mm-hmm.
found the actual video footages stating that there was young boys having sexual relations in a room with twin size bunk beds in children's underwear. And they're saying that she downloaded that for him a month or two before he got locked up in July of 2019. And that she said that he wanted her to download that for him on his phone so he can have something to watch.
Wow. So, if those allegations are correct, as we've kind of stated before, those things allegedly occurred under coercion and duress. The entire case is built upon the duress and the coercion that R. Kelly allegedly had these women under, controlling their
Right.
food, controlling whether they could go to the restroom, et cetera, et cetera. So you are not going to be held legally culpable for something that you did under duress. Now, of course, defense attorneys will try to argue that she did these things because she wanted to. They will make that argument. But that argument will not equate to her being charged with these things. That's just an
Right.
argument they're going to try to use to say, oh, R. Kelly isn't the one who told her to download these things, allegedly.
Right. Yeah, because they're out here in these streets screaming, well, who knows if it was her who wanted to watch the porn? It was her who's being nasty. How do
Yeah,
they
that's what the
prove that?
defense counsel is going to argue. They're
Right,
going to
right,
argue that she downloaded it on her own.
right, right. And then it says here, accordingly, the court should preclude the defendant from introducing evidence regarding the victims engaging in sex acts or contact with anyone other than the defendant or other persons at the defendant's direction or having any type of sexual predisposition. Otherwise, referencing such inadmissible evidence during voir dire, opening statements, cross-examination, and closing arguments. So what is that stating that they don't want them to include her having sex acts except for only with him?
So pretty much they're saying you didn't disclose it. So now we want the court to issue an order saying you are barred from referring to any type of intimate activity that doesn't involve anything that we're charging with. So either your client or someone at your client's residence.
Okay. So all right, that's a good one because according to Don Russell, back in 2018, he did the Surviving Lies Facebook page and wound up trying to expose the girls, especially Jane Doe number 6, her sexual history and having sex with other men, as well as her sending R. Kelly nudes and stuff of that nature. So things like that are barred.
Well, here's the thing. Before I even get to what if they are barred or not, let me say this one more time because for some
Go ahead,
reason
baby.
the internet does not understand this. It doesn't matter if a minor sends someone nudes. The adult who acts upon the minor's conversation with them is still doing something illegal. It doesn't matter if you're saying a minor approached you. Who cares who approached who? The person is still a
Right.
minor and it is still illegal to engage with them. So this entire conversation about who approached who and who sent who a picture and who sent who a message in a bottle is stupid. It's dumb. An adult cannot interact with a minor, period.
Right.
And I get a little bit passionate when I discuss that because I have it irritates me. You know, everyone has their pet peeve. And one of my pet peeves is the fact that we sexualize minors. A minor is a minor. I don't care what they said to the adult. I don't care what they told the adult they wanted to go, and it doesn't matter. The adult is supposed to say, this is a minor, it is illegal. No. That's literally the difference between being a child and being an adult, that you know right from wrong.
That's right. That's right. I agree with you 1,000%, sister, on that. That's my argument in this fight too. It doesn't matter if the girls took off their clothes, threw their pussy in his face. He still was supposed to say no.
Precisely. And the fact that we're even having that conversation is what upsets me, because it just goes to show we do not care about our children. We're really blaming children. A man is being accused of allegedly having contact with children, and we are really blaming the children. How sick of a society are we?
Yes. You know, it's so sick that they are saying that they need to change the laws. Well, let me say something to those people who are stating those things. They did change the law. Back in 18 something, it was actually the age of consent was 10 years old. Then they changed it to 12. Then they changed it to 16, 17, and 18. They're not changing it again. And if they do, I think they should change it to 21. How about that? Shall we continue? Then this next part. Yeah, I'm passionate too,
No,
mommy. I
I'm
feel you.
right there
I'm
with
a
you.
mother too. So, and I was
Hmm.
also a victim. So, yeah.
So
Now, this
I
other
just want to
part.
stay on the
Go ahead,
point of
mommy.
whether or not it's admissible, whether or not it would get in. Um, unless they're using it to talk, to speak directly to how she met R. Kelly or something of that nature, that is the exact type of evidence that would be barred. They're not going to be able to just laissez-faire talk about her past intimate history.
Right, right, right. See? So, all that stuff is irrelevant. Then it says the court should preclude the defendant from cross examining regarding religious beliefs or experiences pursuant to Federal Rule of Evidence 610. Now, the government anticipates that a previous longtime friend and former manager of the defendant, an individual hereinafter referred to as witness number one, and whose identity is known to the government and the defendant, will testify pursuant to a subpoena and judicial grant of immunity about the events surrounding the bribery charged in Racketeering Act 1 of the indictment, which occurred in or about August of 1994. Now, there they are talking about Demetrius Smith, who was his manager and his guide back then. And he was the one who obtained the fake ID for R. Kelly. Now, it also says that the government respectfully requests that the defendant be precluded from cross-examining witness number one about a religious experience described in a book, witness number one, published in 2011. Now, I was reading this book. I haven't finished reading the book, but we will continue to read the book, guys. And it's called The Man Behind the Man. And it was published in 2011 by Demetrius Smith. And it's pretty deep. And it talks about his life as well as what he went through with R. Kelly all those years. He's known R. Kelly since R. Kelly was 17 years old. So now it says that the witness number one detailed various experiences in his life, as well as experiences connected to his years long friendship and working relationship with the defendant. Throughout the book, witness number one discussed his faith as a Christian, expressed his commitment to God, and wrote about times in his life in which he felt either further or closer to God based on his own conduct, including with respect to the defendant. In describing one incident involving the defendant approximately 2 or more years after the charged bribery scheme in Racketeering Act 1, witness number one discussed having a significant spiritual experience with the defendant. Specifically, witness number one wrote that while dining in the restaurant area of an athletic training facility, while the defendant, after a workout session, witness number one was sitting at a separate table, acting as a form of security while the defendant sat with female friends. The defendant made eye contact with witness number one, sat up from his table, and asked witness number one to follow him into the men's bathroom. There, the defendant began to cry and stated in a remorseful voice that he, the defendant, felt the Spirit of the Lord on me. They both began to praise God, and then both began speaking in tongues and praise dancing. And when witness number one heard another voice coming from the defendant, witness number one questioned whether he had heard the voice of the Holy Spirit speaking through Rob. a reference to the defendant, or the devil. During this encounter, because the defendant sounded demonic, witness number one's religious beliefs and practices, including the religious experience described above, have no bearing on his credibility or any other relevant matter under the circumstances of this case. What do you think about that?
So it looks like they think that the defense is going to go for this man's state of mind because he's super religious. And it looks like they're going to try to say that he's a religious zealot and that he has a challenged mental state. And more than likely, they would try to use instances like the one that we just talked about to kind of say, oh, well, look, he's not mentally stable. And here's what's so funny about the court and religion and things like that. So on one end, we have like, in God we trust on our money and all of that stuff. Right. And it is allegedly viewed as a good thing to be, godly and Christian and whatsoever. Right. However, whenever you step into the realm of a court case and a trial, more than often people who are religious to a degree that would be accepted in society, that same religion brought into the courtroom is used to challenge whether or not the person is sane. So in everyday society, you hear someone speaking in tongues and most people would be like, oh, they're just talking to God, right? But in court, that is something that almost everyone agrees is like, are you okay? Are you having some mental issue?
A breakdown, right?
Right. So it's very funny. It's very funny that we pretend to be such a godly society, but when you bring religion into a trial, it is usually used to show that someone is lacking in mental stability. Because here's the thing. The argument is that religion does not connect with logic. So then the argument becomes, you are detached from logic, you are detached from the real world, and it's illustrated by how religious you are.
Right. So do you think that, in your eyes, say if you were on the defense side, what do you think about this witness? What would you think about this witness?
I'm not going to say what I would think about the witness, but what I will say is if I was on the defense side and this witness were taking the stand, I would do exactly what the government is alleging that they are doing. I would go after his mental state, and I would say that he is a religious, I would allege that he is a religious zealot who is not mentally stable, who is speaking to beings that are not actually there. I would also allege that he is probably fabricating these stories by way of his mental instability.
So would you say that this witness credibility and his whole statements and stuff like that, do you think that that's something would be thrown out?
I don't think the witness himself will be not permitted to testify. But I do think that they are going to permit questions about this religious scene that occurred because it goes to his credibility as a witness. And anything that goes to your credibility as a witness is relevant. So I think it's very likely that they will be allowed to cross-examine him about this and perhaps about his religion in general, perhaps, if they can connect it to his mental state. So if they make the argument effectively, as I was saying, that somehow his religious involvement is connected to his mental state, if they make that argument effectively, then they will probably be allowed to cross-examine him on things like, do you talk to God? And when you talk to God, are you talking to God or yourself? Do you hear a voice speaking to you when you talk to God? Right? That's going to be the cross-examination line that they're going to want to walk down to lead the jury towards he's not stable. He's speaking to something that's not there.
Right. Yeah, and because it says the purpose of the rule is to guard against the prejudice which may result from disclosure of a witness's faith. Moreover, the prohibition, I can't even say that word right, under Rule 610 prevents cross-examination of not only the religious belief itself, but certain conduct resulting from religious beliefs, which is basically what you just explained. Wow. So now here they redacted a lot of stuff. They say that the witness's credibility by cross-examining him regarding an act that is meaningful only when considered in relation to the firmness of the witness's religious belief. Okay, they're saying that described above took place approximately 2 or more years after the events surrounding the bribery scheme and occurred decades before. So they're trying to say that his state of mind started losing it a little bit after the fact that the whole bribery happened, right?
Right. So it looks like they're trying to say all of the religious stuff is not in the same time frame.
Right. So that
and
doesn't
thereby
matter.
not relevant. And I will add this on the other side of the argument, being that we talked about the R. Kelly defense side. On the other
Right.
side of this argument, from the government's perspective, who this jury is going to be everything.
Excuse me.
Because if the government can get a jury with people that have some semblance of religion, they're okay. Because if you think about it, if you are a religious person, if you are Christian or some type of religion that involves some level of conversating, I should say conversing with a
Right.
higher power, then you would get it. You're going to say, yeah, he spoke to God. No big deal. I do that too, right? So who the
We all do,
jury
right.
is, right? So who the jury is going to matter. Defense is going to want to make that look like mental instability, and the government is going to want to make sure they get a jury that has some people on there who have some type of God in their lives,
Right.
or they're going to be in trouble with this witness.
Right. Excuse me. I need to get a thing of water. And then it says that that it has no bearing on witness number one's testimony regarding the defendant's sexual relationship with Jane Doe number one of the bribery scheme charged in the indictment. It is thus irrelevant to the charges in this case. Extensive questioning on the collateral issue of a government's witnesses' religious belief might confuse the jury and distract its attention from the principal task of determining whether the defendant had committed the charged crimes. That's funny. Like, listen, that's a distraction. Don't pay attention to that.
That's exactly what they're saying. It's going to distract them and get them off of the real matter at hand and get them onto, is this guy okay? I don't know. What's this religion stuff that's
Right.
going on? Yeah.
I think that's funny how they threw that in. Like, listen, we don't need these people confused. They're already confused. Then there's a bunch of stuff here that is redacted, and it's the defendant should not be permitted to reference prior psychological histories. So in this portion, it probably talks about some of the girls or witnesses, Jane Doe's, John Doe's histories of their psychological stuff, right?
Right. That's probably why it's redacted. And they probably want to say that it's not relevant if they, whatever their mental illnesses might be. And
Right.
also, yet another thing, if somehow it is managed to be brought into the case that some of these victims have mental health issues, that is where being an attorney comes in. Like there's a difference. And I'm not saying this to say that attorneys who are not litigators are not good attorneys, because we need all different
Right.
sorts of people to make the world go round, right? But
Right.
this is
Right.
where you separate litigators from transactional attorneys. So attorneys like me from people who really, they're just, the only thing they can do is write you a contract, right? This is where you
Right.
separate people. How do
Okay.
you deal with things that are not good for you? Can you take something that on the outset isn't good for you and make it work for you? That's what a litigator would do. So they're going to argue that it's not relevant. If somehow any mental health disorders or diseases or anything comes into the trial, a good litigator is going to figure out how to make that work for them. From the
Right.
defense perspective, we know what it obviously would be, right? It would obviously be this person is unstable. From the
Right.
prosecution perspective, You go straight to sympathy. You should go straight to, of course, this person is anxious and depressed. Wouldn't you be if people had been abusing you since you were a
Yes.
child and making you use the restroom in a bottle and making you sleep with your family members, allegedly?
Right. Allegedly.
So
Exactly.
this is where litigators get separated from people who just like to put on a suit and say, I'm a lawyer, right? Are they going to be able to take things that may not necessarily work for them at the outset and make it work for them?
Right. Right. See, this is Ave Maria, but this case is like a circus, bro. Welcome to the big top. So, there's another portion in here that speaks about the defendant should be precluded from making legally irrelevant and prejudicial arguments regarding the parents of certain victims. I saw that. I said, okay, okay. Now, it states that certain racketeering acts and substantive counts allege that the defendant coerced minors, including the individuals identified in the indictment as Jane Doe number 1, Jane Doe number 2, Jane Doe number 5, to engage in sexual activity prior to their being old enough to legally consent to such sexual activity. Now, to prove these offenses, the government expects to present evidence showing that Jane Doe number 1, at approximately 15 years old, Jane Doe number 4 at 16 years old, and Jane Doe number 5 at 17 years old, spent a substantial amount of time with the defendant, despite having not completed high school, and that the defendant may try to deflect the blame for his criminal conduct by offering evidence that the parents of Jane Doe's 1, 4, and 5 knew or should have known about their daughter's sexual relationship with the defendant. And the defendant may further assert that to the extent the parents of Jane Doe 1, 2, and 5 knew or should have known about their respective sexual relationships with the defendant, the parents thereby consented to such relationships. Even assuming arguendo that there was evidence to support such claims, the evidence would have no legal bearings as to the offenses with which the defendant is charged. Indeed, consent by either the parents or the underage victims is not a defense to such charges. What do you think of that?
So they are insinuating, the government is insinuating that allegedly
Right, right,
R. Kelly's defense attorneys may try to go after the parents and say, well, the parents knew about this and the parents were involved. And then let's go back to me and Diva's original, lose it moment that we had just a few minutes ago. It doesn't matter. It
right,
doesn't
right,
matter. A parent could literally hand you their child and say, here you go. You are still doing something illegal if you do something you shouldn't be doing with that child. So again, this would only serve to deflect, but in no way does it help R. Kelly because it doesn't disprove. In fact, you know what it does? It proves because
right,
he's saying the parents said it was okay. Wait, so you're
right,
saying you did it? You're saying you
right,
did it.
right.
So this entire argument, not only is it irrelevant, but it does nothing to help R. Kelly. But the government is insinuating that he may go for that argument. And they would like
Right,
for the judge to just outright preclude it. Because
right,
as they are saying, it is irrelevant. And a lot of people want to know whether or not that opens up the parents to potential prosecution. Yeah, it does. But will they actually be
right,
prosecuted? I doubt it because I'm sure they're cooperating with the government in this case. And as
right,
we've discussed, they probably have received, immunity in exchange for that.
right,
So at the end
Right.
of the day, whether or not the parents knew, whether or not the parents consented, does not help R. Kelly in any way. In fact, it's a low-key confession to say they consented because you are saying that you did it.
Right. So, so in other words, they're going to so because Jane Doe number one, we know it's Aaliyah. Jane Doe number four is Geronda Pace, and five is Azriel. My thing is, so Geronda Pace's parents was involved in this, and that young lady never mentioned anything about. And well, her parent, I guess, knew that she was seeing R. Kelly because she did mention stuff in her book about it, that that she told her mom, and that everybody was like, "Oh, you're dating R. Kelly," like and like it was okay. And of course, we know as Riel's parents, they sent her off to go be with him, to further her music career. And then, of course, we all know about Aaliyah, which he helped get her off the ground and produced her records and stuff like that. So, and according to the mother, Miss Horton said that she was always around. So, you know, um, if they do try to use that, that's just like you said, that's bogus. That doesn't even matter because of the fact that at the end of the day, they're minors and you're in your 30s and you should know better than to be messing with minors. Period. Period. Then it says that accordingly, the defendant should not be permitted to elicit testimony from the government's witnesses, including Jane Doe 4 and 5, during cross-examination, introduce evidence or argue that the parents of the women and girls who are the co-defendant, who the defendant coerced to engage in sexual activity were aware of, consented to, or were otherwise responsible for such activity. Like you said, such arguments are legally irrelevant, and would only serve as a distraction to the jury. Otra vez, what a distraction. Oh man, evidence is not admissible where the risk of unfair prejudice substantially outweighs any probative value of such evidence. So like Miss Esquire said, it doesn't matter. Okay. All right. Let's go to that. Now, they're saying here that the defendant should be precluded from offering evidence of prior good conduct. So the prosecution doesn't want them to talk about his good deeds. Is that what that means?
So the
Right?
prosecution does not want him to offer witnesses who are really character witnesses, witnesses who will really just say, oh, I've known him since, 92 and he's a good guy. They're saying that should not be allowed in because that's irrelevant.
Okay. Conduct is irrelevant. Okay, there we go. Then it talks about evidence of prior good conduct is unduly prejudicial. What does that mean? Unduly
So
prejudicial.
so just to be clear, you said probative. It's actually probative. That's the way that they say it. Just so
Probative.
everyone knows. And then for
Okay.
unduly prejudicial, it means that, so there's a balancing test that every piece of evidence has to go through. And it is called prejudice. It's probative value, that's the full term, versus prejudice. That's the balancing test. So even
Okay.
if a piece of evidence is relevant, even if it is useful, it still has to have more use in the case. It has to be more probative than it is
Right.
prejudicial. So what they are arguing, what the government is saying is, listen, any quote unquote character evidence he's trying to introduce, it doesn't have enough probative value. It doesn't have enough evidentiary value in this case for it to beat the fact that it's going to be highly prejudicial because it's just for the purpose of making the jury think he's a good person.
Right.
So
Right.
that's what they're saying.
Okay. Okay. And in this part, it says that the court should preclude the defendant from admitting evidence or cross-examining Jane Doe's 8's employment as an exotic dancer. So, because she was an exotic dancer, they can't try to bring her down because of that as well, right?
Right, which is what we've already discussed about a person's history and the fact that their
Right.
history is not relevant unless you're going to directly link it to the
Right.
accused charges.
Mm. And then it says that certain text messages by Jane Doe number 5 and relating to Jane Doe number 5 should be admitted. Now they're saying that at trial, the government seeks to admit certain text messages as recorded recollections, prior consistent statements, excited utterances, and present sense impressions. First, the government seeks to admit certain text messages written by Jane Doe number 5 between April 2015 and December 2015, when Jane Doe number 5 was 17 years old and could not legally consent to sexual activity in Florida or California. Second, the government seeks to admit certain text messages written by Jane Doe number 5 and employees and associates of the defendant about several occasions where Jane Doe number 5 and other women with whom the defendant was living, including the individuals identified in the government's motion to admit uncharged acts as to Jane Doe numbers 16, 17, and 18 were subjected to punishment by the defendant, including physical abuse, withholding of food, and isolation. So they're saying that they want to submit evidence proving that he's done abused these women and took advantage of them, right?
Right. So when you hear present sense impression and excited utterance and all those terms
Yes,
are
girl.
hearsay. Yeah, those terms are hearsay exceptions. So
Oh.
understand that a text message could be considered hearsay. And
Mm.
usually you can't admit hearsay. It's an out of court statement. And so you can't use that statement to prove something in court. But there are exceptions to the hearsay rule. So
Mm.
the general rule that you can't use hearsay, there are exceptions. Excited utterance is an exception. Present sense impression is an exception. So they're pretty
Okay.
much saying to the court, hey, we understand that you may be considering these text messages to be hearsay, but they do meet these exceptions. So first, excited utterance is a hearsay exception that is usually admitted to tell the court, well, not usually admitted, that is usually used to tell the court, hey, listen, yes, this statement is hearsay, but it has what we call in the law an indicia of reliability, meaning
Oh,
that for
wow.
some reason it's reliable. Excited
Okay.
utterances are statements that someone makes right after a traumatic event. So, for
Okay.
example, let's say Pinky. For example, Pinky just got shot, right? And then when the
Right.
police arrive, and he's literally bleeding still, and the police arrive and he says, oh my God, I can't believe that Monica shot me.
Okay.
That's an excited utterance. Usually the court might
Mm.
say, oh, you know what? I think that's hearsay. I don't know. But then the prosecution would say, no, it's an excited utterance because he
Right.
said it right after he got shot. It has an
Right.
indicia of reliability because when something traumatic has just happened to you, you don't have
Mm.
the time to think of a lie. You don't have the time to think
Right.
something up that isn't true. The first words that come out of your mouth are going to be reliable because you're still traumatized.
Ah, excited utterance.
So
Got it.
excited utterance.
Yes.
They use excited utterance. I used excited utterance a lot when I
I
was in
do
domestic
too.
violence. Yeah, I used excited utterance a lot. No, not saying that I do it, but I
No, no.
use the excited utterance exception a
I
lot
get
when
what
I
you're
was a
saying.
domestic violence prosecutor because there
Okay.
would be a lot of out of court statements like, oh, my husband just punched me in the face.
Right.
And then, of course, defense would try to say, well, that's hearsay. And I would say, no, it's an excited utterance. It just happened. She was still under the stress of being beat by her husband. So that's excited utterance. Present
Okay.
sense
Right.
impression is when something is actually happening and
Right in the
you are
moment.
making, yes, you're making a
Right.
statement. You better go, Diva Esquire.
Yes, I'm
So
learning, baby.
you're
I love
making a
you. You're
statement
helping me out a lot, sis.
right in
Word.
the moment, right? So, oh my goodness, I'm seeing someone, like if I call Diva and say, Diva, I'm watching Monica shoot Pinky right now. Oh my gosh,
Right.
like he's shooting, right? Present
Right.
sense impression.
Right. And
So
I'm
they are
like, oh my
saying
God, oh my God, oh my God. Like right away, this is,
exactly,
we're right now in the present tense. We're in the moment. This is happening. We can't believe it. We're excited. What is going on?
precisely. So they're saying to the court, hey, these text messages might usually be considered hearsay, and you might be looking at them as hearsay, but they meet these exceptions, so they should be
Right. Because
allowed
these
in.
were happening at these particular moments.
Exactly.
It wasn't like, okay, it happened, and then 7 hours, 8 hours later, somebody got a text about it just to say hearsay.
Right. Right.
Okay. Okay. Got you, sis. Got you. See, I'm learning, girl. But then it says that the text messages the government seeks to admit as well is text messages of Jane Doe number 5. That the government is in possession of a cellular telephone that Jane Doe number 5 used from the time that Jane Doe number 5 first interacted with the defendant at a concert on April 18th, 2015 through June 21st, 2015, when Jane Doe 5 left her phone in Florida and began to travel with the defendant full time. In text messages found on the telephone, Jane Doe number 5 recounted to her mother various interactions that she had with the defendant. For example, shortly after Jane Doe number 5 met with the defendant and played some of her own music for the defendant, she recounted to her mother in text messages how the defendant, went too fast, how the defendant was impressed by her musical talent and indicated that he was going to help her make it in the music business. Now, two of those text messages are below. Now it says she put he, referring to the defendant, liked both. So she said he liked both. He said the video's nice for it just be us doing everything. He also liked my writing. Remember, I sung it for him live, so he already knew. With the beat, he could understand it better. He said he likes how it has that radio ready sound that anyone could relate to. He said it's nice and cute, not too young or grown, but that sound that'll never go out of style. This nigga gassed her up. Yeah, that's why he, referring to the defendant, called me laughing my ass off. He said he want to go in the studio. I think he really want to sign me under him, to be honest. TBH's, to be honest. Then it says, thereafter, the defendant invited Jane Doe 5 to travel from her home in Florida to visit him in California, where he was then performing. At the defendant's instruction, in text messages on April 28, 2015, Jane Doe 5 contacted one of the defendant's assistants, provided her birthday, showing that she was just 17 years old, and requested that the assistant arrange her travel to California. Oh, I went too fast, sorry. Now, on April 29, 2015, at the defendant's expense, Jane Doe 5 flew to California to see the defendant In text messages, Jane Doe number 5 communicated with the defendant's assistant and her mother about the particular hotels where she was staying and the cities to which she traveled. During that first trip to California, Jane Doe number 5 also recounted to her mother some of her interactions with the defendant, including those quoted below. She wrote, "Be talking about rules. But he," referring to the defendant, "got me in sweats. He," referring to the defendant, "ain't like my tights, showing my figure. He just texted me. He said, although he isn't with me, this wasn't a waste of a trip. He said I should use this time to try and ease my mind and soak in everything he's been telling me, so when I actually go into the industry, I'll have a mature frame already. Everyone having fun, and Kells said, do not leave the room." After trial, Jane Doe number 5 will explain that during that first trip, the defendant advised her of certain rules she would need to follow. Be talking about rules, including his direction that she wears sweats rather than form-fitting clothes. He got me in sweats and ain't like my tights showing my figure, and that she should wait in the room for him. Kell said, do not leave that room. The government is also in possession of text messages written by Jane Doe number 5 to two friends, identified herein as friend 1 and friend 2. Those text messages span October 2015 to January 2016 and include messages to friend 1, wherein Jane Doe 5, at the age of 17 years old, describes that the defendant ejaculated inside of her and that she believed she was pregnant. That the defendant wanted her to have an abortion because she was 17 years old and not 18 years old, the age of consent in certain states, including California, where she and the defendant then were, and she feared having to get an abortion. Now, Jane Doe number 5 also describes in the messages how the defendant reviews the messages on her telephone and did not want her to speak with her high school friends, including friend number 1. In messages to friend number 2, which messages were recovered from an iCloud account used by friend number 2 and are further detailed below. Jane Doe number 5 describes how the defendant had confined her to a room in December 2015. And then she said that Jane Doe number 5 later learned that she was not in fact pregnant at this time. What do you think of that hot mess right there?
Wow. I
Yeah,
don't know if
right?
y'all.
Girl.
I had a thought. You know, when you're thinking out loud, I had a thought. So I don't know if you guys heard
Mhm.
me, but if you did, it is what it is. But
No.
oh, okay, all right. So there is a lot going on in these text messages.
Mm.
Now whether or not, huh, I think some of them will be admitted, but perhaps not all. I
Mm.
can already see a lot of argument being made about who is he and what does this person mean when they say he. And so, if in fact if in fact these messages do get in, defense is going to argue that anything that says he, you throw it in the trash can because we don't know who he is.
Right. Right. And then it talks about, okay, that there's also text messages with the employees, you know, and that in these text messages, employee number 1 and employee number 2 refer to Jane Doe 5 as niece or N. After the defendant introduced employee 1 and employee 2 to Jane Doe 5 as Jane Doe 5's aunties. These are your aunties. You know, this is the thing. He always wanted a big family because this is how he treats all these people as his family. That's my brother. That's my cousin. That's my niece. That's my goddaughter. Ain't none of them related to him at all by blood. None of them. He's lacking a lot. I get it. He missed out a lot on his childhood. His childhood was messed up, and he's eventually gotten messed up in his mind. But this does not give you an excuse to do the shit you do. Then it also says that November 4th, 2015, there's also physical abuse of Jane Doe number 5, that there's text messages between employee number 1 and employee 2 showing that employee number 2 witnessed the defendant physically abusing Jane Doe number 5. And employee number 2 will testify consistent with the text messages that she witnessed the defendant arguing with Jane Doe number 5. And then after the defendant asked her to leave the room, she heard what sounded like the defendant hitting Jane Doe number 5 with his hand, specifically in a text message on November 4th, 2015. And then employee number 2 sent the text message to employee number 1. Rob got on niece, referring to Jane Doe number 5, about lying, and already just that quick, she has lied again. But this time was not just a literature. I'll tell you. And another employee of the defendant, employee number 3, later were at the studio and I can't talk. Later, we're at the studio and I can't talk. Later that day, she wrote, I didn't hear the hand, but I heard what was about to take place. So when he, the defendant, asked me to leave, I told him I had to use the restroom. He told me to tell Donnie, another employee of the defendant, to show me where. So by the time I was back in the area, I heard the after fact cries, future consequences. Employee number 1 responded, oh, wow. And do you think he used a belt? To which employee number 2 wrote, hand. Like, so they want to enter all this stuff as proof that he did, there are people who witnessed physical abuse somehow, some way, right? Then,
right. So they do want to use that to establish that there was physical abuse.
Right. And then here, December 10th, 2015, they talk about isolation of her. And they talk about the text messages in here where it says that, where is she? Referring to Jane Doe number 5. What are you? Where are you? I guess she meant to say. And then employee number 2 was like, she's in the back room. I'm still in the front. Employee number 1's like, so he's had her in there all day? Has she come out to use the restroom or eat? Where's R? Where's niece? She came out to go to the restroom and eat. They are still in the next room. They are still in the room next to the studio. And they want to use these things to prove that. Then it says niece has been confined to the room since around 6 p.m. And he has Jane Doe number 16, referring to the other girlfriends of the defendant, including Jane Doe number 17, are upstairs, but he's gone home. When employee number 2 asked 6 p.m. yesterday, employee number 1 responded, yes, yesterday. Actually, maybe around 8 p.m. That same day, as referenced above, Jane Doe number 5 herself sent a series of texts to friend number 2, explaining that the defendant had in fact confined her to her room and the reasons for the confinement. And then those text messages had said, "Oh, I just felt to rebel, so I did." And then I was like, "Can I take a shower? Can I take a shower?" And he, the defendant, was like, "No, you're going to stay in this room until you tell me why you," I guess why she lied or whatever. And then, first of all, I never had an attitude. You always think someone made. And then I kept calling and texting him, the defendant, over and over. So he got upset over some dumb shit, like, and then wouldn't let her take a shower. Like, makes no sense. And then there's some more text messages talking about withholding of food. You know, saying this was in 2016. Now, at this point in time, she's 18. She just turned 18. Her birthday is December 30th or 31st. She had just turned 18. A couple of days after her birthday, he's holding food from her. Like, punished her in the room. Like, then it says, employee number 2 told employee number 1 in the text message, niece, referring to her, Jane Doe 5, hasn't eaten since Thursday. We sat at Red Robin's for hours and he didn't even feed her. Shaking my damn head. I just gave her some chips, queso, cold queso, and clarified in a subsequent text message that she meant has not eaten since Thursday. The government intends to argue that the withholding of food on or about January 2nd is an example of the control the defendant had over Jane Doe number 5, and the control that exerted by the defendant over Jane Doe number 5 extending to dictating when she was permitted to eat. Then also physical abuse, also confinement. Like, do you think that they will use all these other texts as well to show patterns of his abuse?
Oh yeah, they very well may ask to do so, and it'll be up to the judge as to whether or not it's permitted.
Yeah, because Donnelly hasn't answered to this yet. So we don't know. And then they put in some other stuff under seal, so we don't know what happened there. And then it talks about the government talks about the relevance. And that the text messages are highly probative, right? Is that how you say it again?
Probative.
I'm sorry, highly probative of the defendant's coercion of Jane Doe 5 to travel to California for the purpose of sexual activity. So a lot of this stuff that, the government is just basically saying that they want to include all of these things because they prove patterns of his bad acts, his behaviors, his controlling. And then it says that the text messages are not barred by the hearsay rules, right? And you explained that. And excited utterances. It says an excited utterance is a statement relating to a startling event or condition, as you explained to us as well, made while the declarant was under the stress of excitement that it caused, right? Okay, so we got all that out the way. Present sense impressions, you explained that as well. Recorded recollections. Okay, declarant witnesses prior consistent statements. Okay. And yeah, let's see here. Wait, what was this I highlighted here? Okay, so it talks about the analysis of all of it, right? And the government anticipates that Jane Doe 5, employee 1, employee 2, employee 4, and witnesses number 2 will all testify as witnesses for the government, and therefore will be subject to cross-examination by the defendant And while the government anticipates that the witnesses will generally recall much of the conduct described in the text messages above, they do not recall each episode and the timing and details of each episode, and will testify that their text messages about this conduct were accurate at the time they sent them. So, to the extent that the witness recalls the content of a particular episode, the text messages as to that particular episode should be admitted as prior consistent statements to rehabilitate the witness. To the extent that the witness does not recall the content of a particular episode, the text messages as to that episode should be admitted as prior recorded recollections. So, yeah. And pretty much we kind of went over all of this. Oh, then it talks about Aaliyah. Like, they want to submit, right? I think this was it here. Yeah, they want to submit articles, newspaper articles, as evidence. And it says that the government seeks to admit certain newspaper articles as ancient or right? Ancient documents pursuant to Federal Rule Evidence 803. Specifically, the government seeks to admit newspaper articles from 1994 showing that the defendant performed in Macon, Georgia on August 30th of 1994, Albany, Georgia on August 31st, 1994, and Miami, Florida on September 2nd of 1994. So that has to deal with Aaliyah. You know, that's crazy. Can they do that?
Can they admit documents to prove their case regarding Aaliyah? Yeah.
Yeah, like
They've
news
already
articles
charged
about the
allegations
time
regarding
of
Aaliyah. Yeah, and these documents are news articles and things like that. They're not
right,
viewed the same as statements. News
right,
articles have more validity to them than just random statements.
right, right. Okay, so we went through all of that. Okay. Now I wanted to what was that? I wanted to, I'm gonna stop sharing this screen here. We're done with that portion. I just wanted to show you guys real quick a Facebook post that I saw. Do you guys see that? Okay.
Yeah, we can see it, but we can't see the words very clearly.
Okay.
Unless
Okay.
you
I'll
want
read
us
it
to.
anyway. I'll read it. Now, as we all know, this is Dominique Gardner and her fiance. She was with R. Kelly for 9.5 years. And she got the most of it. And she is so happy. And I am so happy for her. You know, he turned her into a boy. Even though she was into girls, because according to Geronda Pace, her and Geronda had a relationship on the low. They were, secretly seeing each other. And her mom, Dominique's mom, didn't approve of that. And then when she got in R. Kelly's grips, I guess she let R. Kelly know, what her mom was feeling as far as trying to pressure her to be with men, maybe, allegedly. and her relationship with Geronda. And then Geronda wound up giving R. Kelly Dominique's number, and she wound up going on her own to spend time with him. And she was back and forth for 9 years. That he even allegedly made her eat feces a couple of times. And Geronda Pace spoke about it in her book. Um, that Dominique told her, yeah, he made me do that. He fed me all these things so that I could do it in a cup, and then I had to eat it just to prove her loyalty to him. He does humiliating things allegedly to these girls to prove their loyalty when they fuck up, according to him. So in this post, it says, I hold a smile because there were days on end where I went without it because of my past experience. But when I met this guy who was determined to keep a smile on my face, I said yes. And now we only have 80 days until we say I do. Congratulations, Dominique. I'm so happy for you, sweetheart. Excuse me for a second, guys. Sorry, guys. Please do me a favor, everyone. Please throw up purple hearts in the chats for all survivors and victims of assault, please. We love you, ladies. And God bless every single one of you. And court is near, trial is near. And I just pray that you women get the justice you seek. Because it's time that this monster be put away. He's hurt so many people. So many people. Even people, these people loved him. These people loved him. And he's taken advantage and hurt every single last one of them. And he's hurting his fans too. But none of you see that. You flying fucking monkeys. I hope you get 50 years. You ain't gotta get 195. I hope they lock your ass up for at least 50 years without parole. You know, it's sad because this man has done a lot to a lot of people. Now, guys, I'm going to put my number on the screen. And anyone wants to call in if you have a comment or you have any questions, please feel free to call. So I'm going to wait for my phone to ring. If my phone don't ring, I'm going to end this live. All right? We're not going to do a panel. We're going to do a call-in. I want people to call in. So if anybody has any questions, I don't care who you are. If you have any questions for Miss Esquire pertaining to the case, please feel free. The number is 347-336-9724. And thank you, everyone, for coming. And thank you, Miss Esquire, as always, for your knowledge.
Absolutely. Like I always tell you, I will come back anytime you like. This channel is a space of, I think, actual legal conversation and common sense within the R. Kelly sector. And honestly, there's not enough of that. I think there's just a lot of sexualizing the minors who are involved and blaming the parents and blaming this person and blaming that person, when at the end of the day, the person who is on trial is Robert Kelly. And I think we should be able to be adults and have an unbiased conversation about the accusations against him.
I agree. And we have a caller. Hold on one second.
Hello, Miss Esquire.
Do you hear her?
Hello.
Hi,
I
this is
can hear her.
Michelle Jordan.
Okay.
I am doing fine. Thank you for taking
Hi,
time out
Michelle.
with us.
How are
I'm
ya?
sorry I'm not in the chat. I'm out and about, but I have been listening as normal. My question pertains to the, how do you pronounce it? The limine?
Did you hear her?
The motion in limine.
Yeah.
Yeah, limine.
Yes, her question pertains to the motion in limine.
Okay.
Yes, the defense actually did a response, and they are stating that they did not have knowledge of the John Does. And I remembered when the motion of limine was read from the prosecution, it was saying beside each John Doe that the defense was aware. So I'm trying to figure out how they can turn around and say they don't have the information and they don't know who these people are when all of that was turned in with the 3500 material. Are they trying to say that the government withheld something? Or is, because I'm just thrown and I'm confused about how that was even placed into their response.
Right.
So it could be that what they are arguing is that although they are aware now, it was not disclosed within a timely manner. I believe their argument is that this was recently disclosed.
Right. Oh, she got kicked out. Oh no, what happened? She must have lost her internet or something. Hold on, Michelle. She'll be right back. That was a great question. I don't know what happened, Mama.
Yeah, I don't know either. StreamYard kicked me out.
Yes, it did. I was like, oh, she got kicked out. What the hell? What the
That was so weird. But I was saying that I believe their argument is that it wasn't disclosed timely. So they are admitting that they're aware now, but they're trying to argue that it wasn't disclosed within the time limit that it should have been disclosed.
Okay.
Oh, and see, the problem, and this will be my last thing because I know you have other things, but the last thing about that is everything is being an argument about the timeliness of it. But according to what we've seen happen, the timeliness got messed up when he fires the attorneys only a couple of, a few weeks before the trial. And now is all this about we haven't had time to prepare. Of course, the new attorneys haven't had time to prepare because they weren't on the case. So I'm just trying to see how much of this is stall tactic, how much of this is that they really think the government didn't vet things and didn't do their job. I'm just very confused on some of the things that were placed in their response.
So it could be stall tactic, and quite frankly, anything could be stall tactic. The firing and rehiring of new attorneys could also be a stall tactic.
Okay.
Good question. Great question, Michelle. Thank you so much.
Thank you so much. And I love watching your channel. You're doing a great job. And Diva, as always, you're doing a great job as well. Y'all have a wonderful day. And thank you so much for this live. Very informative.
Thank you, Mama.
Wonderful.
You too.
You too. Have a good day.
Okay, anybody else? Anybody else want to call in and ask a question? Anybody else going once, going twice? And please don't forget, guys, to hit that like button. Please just take 2 seconds of your time and hit that like button. Thank you. And if you are not subscribed to my channel, please subscribe to my channel. And you can also follow Miss Empowered Esquire TV. Oh my God. Keep says, if any of you are talking about R. Kelly on your social media, especially Twitter, please use the pictures of him in his jail uniform. Hashtag keep R. Kelly down. Oh, wow. Oh, snap. You know, so that's just like the gist of all of that. All questions have been answered. Miss Esquire, you are the bomb, lady.
Thank you. Thank you. I love being here. I love answering these questions and encouraging, like I said, some logical conversation in this sector because it's too much craziness.
Yes, yes, yes. Now, there was one thing I wanted to show to you guys that I found to be kind of weird because R. Kelly made a song, right? Called She's Got That Vibe, right? Does everybody remember that song? Everybody remember that song? She's Got That Vibe. Well, he released that song in 1992, right? Age Ain't Nothing But a Number was released in 1994. So in 1994, Aaliyah was what? 15, 14 years old, correct? Right? So in 1992, Aaliyah had to be what? 12? Right? She was born in 1979, guys. So 1979 to 1992. She was 12 years old, right? He made this song. Now I'm going to share this because it has the lyrics. Let me go back to it. I just want to show y'all one part of the lyrics here. Hold on. You know, his lyrics are they're funny. Let me all right. Let me share my screen.
Hey, yo, R. Kelly, what's up, man? You been spending a lot of time.
Let me know if you guys can hear it in the chat.
Got the vibe, you know what I'm saying?
I mean, even though I don't care about the words, I mean, I don't care about the music. Matter of fact, you know what? I'm not even going to share the song. I just want you guys to see the lyrics. I'm going to put it widescreen. Okay. All right, now I'm going to go back to it. Okay. Now, all right, wait a minute. Hold on. Okay, now I'm going to play. Here we go. Now it says, you see, I don't know, man. She just got that vibe. And then he goes vibe and he sings all the vibe, right? Vibe. He's going to the chorus. Let me get to this part. Trying to get to the next song. I'm trying to get to it. He just says the vibe so much. Okay. I'm sorry. Now here he says, ooh, stop the press. Girl, you turned me on. And I wonder if I could take you home. I must confess, the tight miniskirt you wear, I just can't help it. Baby, I can't help but stare. So, hold on. He says, so tell the DJ to pump it up a little more. Hey, girl, I gotta let you know that you've got that vibe. Right? Then he sings the chorus. Vibe. Yeah, she got that vibe, right? Goes on to the chorus. Then he says, it's 1 o'clock and the party's just beginning. The place is jumping. Ooh, what a lovely scene. Gotta let you know the deal. I want you now, baby, and I'm for real. So tell the DJ to pump it up a little more now. Baby, I gotta let you know that you've got that vibe, right? Okay, then he says the vibe chorus again. Okay, then here he says, yeah, how would you like to get a piece of this pie? You could be my girl and I could be your guy. Yeah, cuddle me in your arms like I'm your teddy bear. There, isn't that nice? You'll have no fear. Yo, kiss me, you fool, and make me melt like butter when it comes to saying I love you. I won't stutter. The fuck? I never really I never really sat down and listened to these words. And then he's singing this to a bunch of girls. He names them. Then he says, I'll turn you on like a neon light, make everything all right, like in the middle of the night. Yo, when you need somebody to love you like Flintstones, he implies Flintstones, we'll have a yabba dabba do kiss and caress you and hold you, and my word is bond. Yo, PA, what's up? She's got that vibe. Huh? What? I can't even believe this guy. The lyrics. What does he talk? What? He implies Yabba Dabba Doo and Flintstones. He's serenading a bunch of little girls. This is what he's doing. This is what he's doing. And then he sings the vibe, da 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 da. Okay, boo-doo-doo, more, all right, doo-doo-doo, let's see. Then he says, so after he says she's got that vibe, then he says, Joanne's got it. Lanice has got it. Teresa's got it. Tonia's got it. I tell you, Cheryl's got it. Boy, I tell you, Betty's got it. Chip has got it. Ann's got it. Gail's got it. Stephanie's got it. Sabrina's got it. All these girls. I wonder who these girls are. We know some of these girls, right? I wonder. Teresa, his sister. Ooh. Chip, is that a boy or a girl? Right? Right? Like, then he says, wait, who's the other girls? Rochelle has got it. Gladys got it. Montina's got it. He was talking about Montina Woods, the girl who he allegedly videotaped without her consent. Then he says, this is the best part of it all. Little cute Aaliyah's got it. Oh, Stacy's got it. I tell you, Tina's got it. I tell you, Rhea's got it. Oh, Laura's got it. And Kim's got it. He mentioned Motina, and he even mentioned Aaliyah. And who knows if Teresa is his sister. And then he says the vibe, da 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 da. Then he says, go to work on me. And he repeats that. Go to work on me. And he repeats it. And then he repeats his vibe verse. And that's the end of that. Why are you saying a 12-year-old little girl got a fucking vibe, and then you're telling her, come work on me? We gonna kiss like yabba dabba doo? You sick ass pervert. If those weren't clues, I don't know what the fuck is. Okay? OMG. And even his daughter's named Joanne. His mom, his daughter, like, what? Yes, Montina Woods. Montina Woods. He even put her in there. What? Remember, Montina Woods was around even with Demetria Smith. I spoke about her in the book. He wrote about her in the book. Montina Woods was around for a little while. She was one of those little girls running around in the studio, hanging out. That is sick. This man is sick. Okay? And he needs help. He needs help. He needs serious help. And I wanted to see if I can show you something else, guys. Hold on. I'm going to, let's see. Wait, where is it? It was over here. Then I wanted to show you this other song. Now, it was a remix to what was the song again? The remix to shit, what was the name of that song? Where is it? The remix to Your Body's Calling Me. Hold on, let me see if I can. Okay. Now, now, when he made this song, Your Body's Calling Me, I forgot what year that was exactly. I'm going to look it up again, too. Espérate. Is this the one with the lyrics? Wait, let me make sure. Is this supposed to be? Yeah, this is supposed to be with the lyrics. Okay. So I'm going to play the video. Let me show it. It's crazy because this guy. Okay, so it's on the screen. All right. Now this is the remix, and it's the remix to Your Body's Calling, right? It says, I can tell by the way you flex that you're horny. Hey, ain't no sense in beating around the bush. Tell me you want me, baby. Right. You want me, baby. And it says, so stop stalling, baby. Come on in this room. Yeah. Close the door behind ya. Lay your body right next to Mr. Bump and Grind ya. Okay. Yeah, he really is creepy. And I think, let me see, wait. Yeah. Okay, yeah, this is him still. He's saying, here I am looking at you from head to toe. So don't you have no fear? Listen, do you hear what I hear? Hold on a second, guys. Yo. Miss Esquire, you're still here with us, right? We have another question.
I am. What's the question?
Okay.
Hi, Miss Esquire. And again, thank you. Chat, hello. It's me, Pettyville. Okay. Hi, Miss Esquire.
Lower your YouTube.
Yeah, I just turned it off.
Okay.
Okay. So my
hold on.
sense is to kind of entertain something for a second here. There's a lot of chitter chatter about possibly this whole case being dismissed on Tuesday, according to the response that the defense has put in. What is the likelihood of that happening, possibly, if at all?
Miss Esquire, did you get to hear her? Oh, she said give her a second, so I guess maybe she had a call. Give her a moment. I'm sorry.
Okay, nope, that's fine.
Yeah, so yeah, that motion, they're bugging out. They need to stop. That has nothing to do with anything being dropped. Just because they hid some motions and they put them under seal doesn't mean that Rob is walking free.
Eva, you know I know this.
Yeah.
I'm just being petty.
I know.
And entertaining.
I know.
And I want to get a professional stance on that.
Yes. Yes. Uh-oh, something happened to her. I don't know. We lost her.
Okay.
Hold on.
Jennifer, I'm reading your question. Yes, and I'm trying to figure that out too. I'm trying to figure out where.
Wait. Give me 1 second, Petty. Miss Esquire.
Yes, I'm back. So I only got the first part of the question where the caller was saying that there are rumors that the entire case will be dismissed.
Right now, go ahead, Pettyville.
Yeah, I was just trying to figure out, off of the defense response, how could someone come up to that conclusion that this entire case will be dismissed?
So if the case was going to be dismissed, it would have already been dismissed. It is highly unlikely that a case gets quote unquote dismissed when you're on the eve of a trial. You go through several preliminary evidentiary hearings before you ever get to a trial.
Right.
Exactly. Right. So I was just wondering what
more than likely, what would be what would get this case dismissed? Let's ask that.
Yes, that's a better question, a better way.
Okay, so what would get this case dismissed? A Brady violation? Let's see, what else? Yeah, I mean, other than a Brady violation, I don't see how else this case could be dismissed. They're not relying, although not having certain witnesses might hurt them, they're not relying on witnesses. They allegedly have videotapes and things of that nature. So the only thing that I can see getting this case dismissed is a Brady violation.
And
I'm sorry, Diva.
No, go ahead, Mommy.
And at this point, the defense has not brought that up in a motion or anything about a violation in the Brady, correct?
Not that I'm aware of.
No.
Okay. I didn't think so. Okay. Thank you, and I appreciate you both so much. Thank you.
Thank you. You're welcome, Pettyville.
Bye-bye.
Bye. So that answers that question. Like, listen, stop it. You crazy ass groupie supporters. Stop it. Stop. Y'all need to sit down and stop.
And yet again, they are hurting his case. They are not helping. If it is in fact supporters that are spreading this rumor, quote unquote, they're not helping. They are only proving that this jury should be kept away from any semblance of the internet. And they are only proving that he is a flight risk because he has people who are willing to do anything to get him out of prison.
Girl, and that's a fact. Y'all need to stop. It's a funny thing because everybody says, we love R. Kelly. If you really love somebody, you sit the fuck down and don't help. You pray. And you talk about the good things, the good times of the man. Celebrate his life, his legacy, not hurt his case. You see, us over here, I wanted to respond to Miss Spit and Fire. She had the nerve to say that us over here, we say we're for victims, but we're not fighting for the victims. And we're not talking about the victims. And we're not doing this and we're not doing that. We don't want to hurt the victims. We don't want to hurt their case. So we are going to sit down, have several seats, shut up, and listen and learn. We are on R. Kelly's neck. Why? Because he's the perpetrator in this. And that's our way of showing the victims that we support them. Okay? The same way you guys want to go and talk about the victims, that's showing your support, right? But you guys are out there spewing lies and conspiracy theories, and that doesn't help his case. You see, over here, we're just talking about news articles, documents, the case, and things that pertain to the case. We're not going off of, oh, Fulana said that she jumped off the bridge and then the other one jumped off behind her. We don't give a fuck about that. That's not our issue. Our issue is to talk about R. Kelly's case, and our issues are to talk about how he has done these girls wrong and these John Does wrong. And yes, it may all be hearsay, but not everybody's lying. You know, it's like, you know, the boy who cried wolf, man. He keeps lying and lying and lying and lying and lying. Eventually, when he really does need help, like he does now, nobody's really there to help. Nobody's really there to help him. Everybody's there to keep him where he is. So this is our way of fighting for victims, Spit and Fire. Just so you know. Okay? This is our way. You do your way, we do our way. Okay? Okay. Lord. And yes, drop those rallies. Those rallies are worthless. You're not making a stance. You're not making any real noise. What yous are doing is looking crazy and informative. That's how yous look. Yous are walking around admitting that your king did what he did. But yet y'all standing there fighting for him. But yet yous are admitting that he did what he did. Where were the parents? One man and no enterprise. They're not volunteers aren't victims. What the fuck? What? Volunteers are not victims. He shouldn't have volunteers who became victims. How about that? And they were minors. And there's even some women in this case. It's not even all about minors. And now there's boys too. And everybody's always saying, why is it that Robert, all these people surrounding him? I can't. Why would he have all these people, all these criminals? Everybody in this case has a criminal background. You want to know why he had all those people around him? Let me tell you why. Because he's a fucking criminal himself. You see how that works? Great minds think alike. You gotta, to have a criminal mind, you gotta have a criminal crew. Your crew gotta be as criminal as you are to do the things that you do. And they look at it and say, it's okay. You can keep doing what you're doing, bro. As long as I keep smoking them blunts, drinking that Henny, and you keep hitting me off with hundreds of dollars every day and buying me food, it's okay. I'll bend over for you. I love you. It's a damn shame. Well, guys, we've been going on for 2 hours. Miss Esquire, I love you, sis. You already know. And as more things come out, I will shoot them your way and bring you back. And we will keep staying on R. Kelly's neck until he is convicted. And then even after that, we might even go after him a little bit more just to, just because we've waited so long for this day. And I still love you, R. Kelly. I love you. It's fucked up. I don't say I love you because I don't know you. I don't know you. I still love your music. Let me correct myself. I still love your music. Some of the music I can still listen to, but this crap right here, nah. I would never listen to that music ever again. Certain songs I just would never listen to ever again. Ever. Ever. Ever, 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 never. And let me don't forget, guys, please hit that like button. Subscribe if you are not subscribed to my channel. And if you are going to watch the replay to this video, please make sure you leave comments below in the box, in the comments section of the video. And Miss Esquire, as always, we love you and thank you so much again. You guys, would like to donate to the channel, y'all already know. Cash App is Diva Divine Light. I put the information, I pinned it to the chat. You could also Zelle me at 347-664-9253. And also you can PayPal me at Diva Divine Light. And thank you so much, guys. You guys have been wonderful. I will do another segment and we will go through his music. I want to do a segment and go through his music. Yes, he did make inspirational music, but a lot of his music, he talks a lot through his music. We just didn't pay attention, but we're going to pay attention now. And once again, hello, everyone. Thank you for coming. I love you guys. What's up, my family? OCOV is in the building. I love you guys. What's up, Robert? Take our Kelly. Give us back to Pop. Word up. Sharice, Mom Life. What's up, baby? Keep the truth. Tasha. What's up, Mama? What's up, what's up, what's up, everybody in the building? Jennifer. What's up, Mommy? Mom Life, Truth Strong. Dorothy. What's up, baby? I haven't seen you in a minute, Mama. What's up? Diva Time. Chula. What's up, Mommy? Danny. Hey, Danny. How are you, honey? All right, all right, all right. My family was in the building. Travis. What's up? My new fan. What's up? Queen Keish. What's up, sis? Idelia. What's up, Mommy? I haven't seen you in a minute, Chula. What's up? What's up? What's up? T-Bone. What's up? Linda B. Hey, Mama. All right, just shouting everybody out. I hope I didn't miss anyone. If I did, my apologies. Candy Cane. Tonya. What's up, Mommy? Missy. What's up, what's up, what's up? And everyone, thank you so much. I love you guys. And Diva Divine Light and Miss Esquire, we are out. Peace.